Judgment in the matter of Telereal Trillium versus Hewitt Valuation Officer.
Lord Carnworth will explain the decision of the court.
This is a rating case. Mexford House is a 3-storey block of offices in the North Shore area of Blackpool. The issue in the appeal was how to determine its value for rating purposes. That depended on the rent which would have been payable by a hypothetical willing tenant at the relevant date. The difficulty was that at the relevant date the property was itself unoccupied, and there was in the real world no evidence of an actual tenant willing to pay a positive rent for it. There were, however, other comparable properties in the area let at substantial rents. Before the upper tribunal, the valuation officer gave evidence in support of a value of £370,000, assessed by reference to the rents of those other properties. However, in cross-examination, he was forced to accept that at the relevant date he could not identify anyone in the real world who would have bid for the tenancy at such a level. After his evidence was complete, the proceedings took an unexpected turn. Counsel for the parties informed the upper tribunal that the issue between them could be decided as a matter of law upon an agreed basis of fact, and that no further evidence was therefore required. They lodged a joint position paper in which they agreed the factual position as conceded by the valuation office. But they identified the question for the tribunal as being whether in those circumstances, in the absence of an actual potential tenant, rating law required the rateable value to be assessed by reference to the general demand, as evidenced by the occupation of other office properties with similar characteristics. It was agreed that if the answer was yes, the correct rateable value was £370,000, if no, £1. The upper tribunal answered the question yes, but the Court of Appeal disagreed. The Supreme Court now allows the appeal by a majority, the leading judgment being given by myself with the agreement of Lord Reid and Lord Lloyd-Jones, while Lord Briggs gives a dissenting judgment with which Lady Black agrees. The majority judgment reviews the case law going back to the 19th century, which showed that the underlying test was whether the occupation was of value to a potential tenant. This could be contrasted with cases where, as it was put, land was, quote, struck with sterility in any and everybody's hands. On the same basis, earlier lands tribunal cases had rightly drawn a distinction between a property which was capable of valuable occupation, but was unoccupied merely because of a surplus between supply and demand in the market, and a property which had, quotes, reached the end of its economic life. Whether an actual tenant had been identified at the relevant date was not critical. The tribunal in the present case had been entitled to conclude that there was nothing in the joint position paper, in the absence of other material evidence, to exclude consideration of the likely level of rent paid by a hypothetical tenant, assessed by reference to rents payable for other office properties in the area with similar characteristics. Lord Briggs, dissenting, does not disagree with the majority's statement of the legal principles, but he reaches a different conclusion about the effect of the agreed position paper. In his view, if the evidence shows, or it is agreed that there is no demand at all for the subject property, the rating hypothesis does not require a departure from that real-world conclusion merely because the subject property is in theory capable of beneficial occupation.
Thank you. The court will now adjourn.